Independence of high courts. The independence of high courts is a basic feature of the Indian judicial system. The Constitution of India provides several safeguards to ensure that high courts function freely and impartially, without interference from the executive or the legislature. Judicial independence is necessary for the protection of fundamental rights and the rule of law. Firstly, the appointment of High Court judges is done by the President of India after consultation with the Chief Justice of India, the Governor of the state, and the Chief Justice of the concerned High Court. This consultative process reduces political influence and ensures appointment of competent judges. Secondly, judges enjoy security of tenure. They hold office until the age of 62 years and can be removed only by a difficult impeachment process on the grounds of proved misbehavior or incapacity. Thirdly, the salaries, allowances, and service conditions of High Court judges are fixed by law and are charged on the consolidated fund of the state. These cannot be reduced during their term of office, except during a financial emergency. This financial security prevents pressure from the executive. Fourthly, High Court judges are prohibited from practicing law after retirement in the same High Court or in subordinate courts, which ensures impartiality and integrity. Lastly, High Courts are declared courts of record under Article 215 and have the power to punish for contempt of court. This power protects the dignity and authority of the judiciary. Thus, through these constitutional safeguards, the independence of high courts is maintained, enabling them to act as guardians of the Constitution and protect the rights of citizens. Jurisdiction of high courts. An overview. The jurisdiction of high courts means the legal authority given to them to hear, decide, and interpret cases. The Constitution of India grants wide and important powers to high courts, making them the highest judicial authorities at the state level, subject to the appellate jurisdiction of the Supreme Court of India. Because of their wide jurisdiction, high courts play a crucial role in maintaining the rule of law and protecting citizens' rights. The jurisdiction of high courts can be broadly classified into original jurisdiction, writ jurisdiction, appellate jurisdiction, supervisory jurisdiction, judicial review, and court of record powers. Through original jurisdiction, high courts hear certain cases directly for the first time, such as matters relating to enforcement of fundamental rights or cases assigned by law. Under writ jurisdiction, Article 226, high courts can issue writs like habeas corpus, mandamus, prohibition, certiorari, and quo warranto to protect fundamental rights as well as other legal rights. High courts also exercise appellate jurisdiction by hearing appeals in civil and criminal cases from subordinate courts. This helps in correcting errors and ensuring justice. Under supervisory jurisdiction, Article 227, high courts supervise and control all subordinate courts and tribunals within their territory to ensure proper functioning. They also exercise judicial review by examining the constitutionality of laws and executive actions. Further, as courts of record under Article 215, high courts have the power to punish for contempt of court. Thus, the wide and varied jurisdiction of high courts makes them powerful institutions for delivering justice, safeguarding the Constitution, and ensuring effective administration of law at the state level. Original jurisdiction of high courts. The original jurisdiction of high courts means the power of a high court to hear and decide certain cases in the first instance, that is, directly without the case coming from a lower court. This jurisdiction is provided by the Constitution of India and by various laws made by Parliament and state legislatures. Under Article 226, high courts have original jurisdiction to hear petitions for the enforcement of fundamental rights and other legal rights. Any person whose rights are violated can directly approach the High Court by filing a writ petition. This makes the High Court an important protector of citizens' rights. The writ jurisdiction is an important part of the original jurisdiction of high courts. Some high courts, such as the Bombay, Calcutta, and Madras High Courts, enjoy original civil jurisdiction in certain civil cases of high monetary value. This power is mainly historical and comes from the pre-Constitution period. In such cases, Parties can file civil suits directly before these high courts without going to subordinate courts. High courts also have original jurisdiction in matters such as contempt of court, election petitions, and disputes relating to the interpretation of the Constitution or laws, where provided by statute. Thus, the original jurisdiction of high courts enables them to directly deal with important legal and constitutional matters and ensures quick and effective justice. Writ jurisdiction of high courts. The writ jurisdiction of high courts is one of their most important constitutional powers. It is provided under Article 226 of the Constitution of India. This article empowers every high court to issue writs for the enforcement of fundamental rights as well as for the enforcement of other legal rights. Because of this wide power, high courts act as strong protectors of citizens against illegal actions of the state and its authorities. Under Article 226, high courts can issue 5 kinds of writs: habeas corpus, mandamus, prohibition, certiorari, and quo warranto. The writ of habeas corpus is issued to protect personal liberty and to order the release of a person who is unlawfully detained. Mandamus is issued to command a public authority to perform a legal duty. Prohibition is issued to prevent a lower court or tribunal from exceeding its jurisdiction. Certiorari is issued to quash an illegal or unconstitutional order of a lower court or authority. Quo warranto is issued to question the legality of a person holding a public office. An important feature of the writ jurisdiction of high courts is that it is wider than that of the Supreme Court. While the Supreme Court issues writs only for the enforcement of fundamental rights under Article 32, high courts can issue writs for other legal rights also, even when fundamental rights are not directly involved. Moreover, a high court can issue writs not only against the state but also against local authorities and, in some cases, private bodies performing public duties. Thus, the writ jurisdiction of high courts plays a crucial role in maintaining the rule of law, preventing abuse of power, and protecting the rights and liberties of citizens. It makes the high courts powerful guardians of constitutional and legal rights at the state level. Appellate jurisdiction of high courts. The appellate jurisdiction of high courts means the power of a high court to hear appeals against the judgments and orders of subordinate courts within its territorial jurisdiction. This power is provided under various provisions of the Constitution of India and different laws such as the Civil Procedure Code and the Criminal Procedure Code. Through appellate jurisdiction, high courts ensure that justice is properly delivered and legal errors made by lower courts are corrected. In civil cases, high courts hear appeals against the decisions of district courts and other subordinate civil courts. These appeals may relate to questions of law, fact, or both, depending on the nature of the case and the provisions of law. In criminal cases, high courts hear appeals against convictions, acquittals, and sentences passed by sessions courts. High courts also have the power to confirm death sentences passed by sessions courts before they can be executed. High courts also exercise appellate jurisdiction in revenue, taxation, and administrative matters, where statutes provide a right of appeal. This appellate power helps in maintaining uniformity in the interpretation of law and ensures that subordinate courts function according to legal principles. Thus, the appellate jurisdiction of high courts is an essential part of the judicial system, as it protects the rights of parties and strengthens public confidence in the administration of justice. The supervisory jurisdiction of high courts is provided under Article 227 of the Constitution of India. This power gives the High Court authority to supervise and control all subordinate courts and tribunals within its territorial jurisdiction. The purpose of this jurisdiction is to ensure that lower courts function properly, follow the law, and do not exceed their powers. Under Article 227, the High Court can issue directions, orders, and guidelines to subordinate courts. It can interfere when a lower court acts without jurisdiction, fails to exercise jurisdiction, or commits serious errors of law or procedure. However, this power is discretionary and is used carefully. The High Court does not normally interfere in every small error, especially when an alternative remedy like appeal is available. The supervisory jurisdiction helps in maintaining discipline, uniformity, and efficiency in the judicial system. It ensures that justice is not defeated due to misuse of power or procedural irregularities by subordinate courts. Thus, Article 227 strengthens the role of high courts as guardians of justice and helps in the smooth administration of the judicial system. The power of judicial review is one of the most important powers of the high courts exercised mainly under Articles 226 and 227. Judicial review means the power of a court to examine the constitutionality and legality of laws, executive actions, and administrative decisions. This power is derived from the Constitution of India and is essential for maintaining the supremacy of the Constitution. If a law passed by the state legislature or an action taken by the executive violates the provisions of the Constitution, especially fundamental rights, the High Court can declare such law or action invalid or unconstitutional. In this way, High Courts act as guardians of the Constitution and protect citizens from misuse of power by the state. The power of judicial review acts as a check and balance on the legislature and executive. It ensures that all authorities act within their constitutional limits and follow the rule of law. Judicial review does not mean that courts interfere in policy matters. They interfere only when constitutional or legal limits are crossed. Thus, the power of judicial review strengthens democracy, protects individual rights, and upholds constitutional governance. High courts are declared courts of record under Article 215. Being a court of record means that the judgments, orders, and proceedings of the High Court are officially recorded and preserved. These records have evidentiary value and cannot be questioned in any other court. The decisions of a High Court are binding on all subordinate courts within its territorial jurisdiction. As courts of record, High Courts also have the power to punish for contempt of court. Contempt of court refers to any act that disrespects the authority of the court, disobeys its orders, or interferes with the administration of justice. Contempt may be civil contempt, such as willful disobedience of court orders, or criminal contempt, such as scandalizing the court or obstructing judicial proceedings. The power to punish for contempt is necessary to maintain the dignity, authority, and effectiveness of the judiciary. However, this power is exercised cautiously and only in serious cases. Thus, the status of high courts as courts of record and their contempt powers play a vital role in upholding the rule of law and ensuring proper administration of justice. Transfer of judges and benches. The transfer of High Court judges is provided under Article 222 of the Constitution of India. The President of India has the power to transfer a judge from one High Court to another, after consultation with the Chief Justice of India. The consent of the judge is not mandatory and is to maintain judicial independence, prevent local influence, and promote national integration in the judiciary. Transfers are generally made in the public interest and not as a punishment. To protect judges from hardship, the Constitution provides for compensatory allowances when a judge is transferred to another high court. High courts may also have benches at different places within the state. These benches are established to make justice more accessible to people living in distant or large states. For example, instead of traveling to the principal seat of the High Court, people can approach a nearby bench. The Chief Justice of the High Court decides the distribution of work among benches. Relationship with the Supreme Court. The relationship between the High Courts and the Supreme Court is clearly defined by the Constitution of India. The Supreme Court of India is the highest court of the country, while High Courts are the highest courts at the state level. High Courts are independent constitutional courts, but their decisions are subject to appeal before the Supreme Court in constitutional, civil, and criminal matters. Under Articles 132, 133, and 134, appeals can be filed before the Supreme Court against judgments of high courts. The Supreme Court also has the power to grant special leave to appeal under Article 136. Further, the Supreme Court's judgments are binding on all high courts under Article 141, ensuring uniform interpretation of law throughout India. However, high courts are not subordinate to the Supreme Court in administrative matters. They have their own jurisdiction and powers, including writ jurisdiction under Article 226. Thus, the relationship between the Supreme Court and High Courts is based on judicial hierarchy and cooperation, ensuring effective administration of justice and protection of constitutional values. Importance of High Courts. High Courts play a very important role in Indian democracy. They are the highest courts at the state level and act as guardians of the Constitution of India. One of their most important functions is the protection of fundamental rights of citizens. Through their writ jurisdiction under Article 226, High Courts provide quick and effective remedies against illegal actions of the government and public authorities. High Courts also help in maintaining the rule of law by exercising the power of judicial review. They can declare unconstitutional laws or executive actions invalid if they violate constitutional provisions. This acts as a strong check on the misuse of power by the legislature and executive. By supervising subordinate courts, High Courts ensure fairness, discipline, and uniformity in the justice delivery system. In a large country like India, High Courts make justice more accessible to people compared to the Supreme Court of India. They hear appeals, correct errors of lower courts, and build public confidence in the judiciary. Thus, High Courts strengthen democracy by ensuring justice, protecting rights, and upholding constitutional values. In conclusion, High Courts occupy a vital position in the Indian judicial system. They are constitutional courts established under the Constitution of India and act as the highest courts at the state level. Through their wide powers, High Courts ensure the protection of fundamental rights, maintenance of the rule of law, and effective administration of justice. High Courts exercise original, writ, appellate, supervisory, and judicial review jurisdiction, which enables them to check misuse of power by the legislature and executive. Their independence is protected through secure tenure of judges, fair appointment procedures, and financial security. As courts of record, they also have the power to punish for contempt, which helps maintain the dignity and authority of the judiciary. By supervising subordinate courts and making justice accessible to the people, High Courts strengthen public confidence in democracy. They act as guardians of constitutional values and ensure that governance is carried on according to law. Thus, High Courts play an essential role in upholding justice, liberty, and equality in Indian democracy.